Good evening, everyone. My name is Alison Duxbury and I'm the Interim Dean of Melbourne Law School, and it is my pleasure to welcome you here this evening for the Flos Greig Lecture. I want to begin by acknowledging that we meet on the traditional lands of the Wurundjeri people of the Kulin Nation, and I want to pay my respects to their elders past, present and emerging, and to any Indigenous people who join us today at this lecture. Tonight we have a guest speaker whose record and career matches the esteemed legal service and spirit of this lecture's honorific, Flos Greig. Our speaker this evening is the former Governor of Victoria, the Honourable Linda Dessau. I will introduce the former Governor in a moment, but first I want to speak about the foundation of this lecture and a little bit about Flos Greig. Grata Flos Greig was the first Australian woman to be admitted to legal practice and a Melbourne Law School alumna. She was a true pioneer whose determination to practice as a solicitor and advance gender equality in the legal profession in Australia in the early 20th century was unparalleled. In fact, Flos Greig was from a family of women pioneers. Her two older sisters, Jane and Janet, both graduated from medicine. To give you a flavour of the position that Flos found herself in when she arrived at the University of Melbourne in 1897, Iola Matthews' book, Iola sitting right there, on Flos Greig notes that a few years earlier, the law students' magazine, The Summons, stated in relation to women lawyers that the first alarming feature of this innovation be the substitution of emotion for pure reason as the groundwork of legal argument. What chance would the less favoured male counsel have, despite his erudition, against an adversary with smiles and tears and blushes at her command? Flos's arrival on the campus a few years later inspired a 4-verse poem. However, Flos clearly had the last word when she graduated second in her year. Now, I recommend Iola's book to the audience because it gives one of some really quite interesting flavours around Flos's life and her career, and of some of her public speeches that she gave at the time. For example, apparently when faced the assertion that giving the vote to women in Victoria would cause the breakdown of the home, Flos replied that it was well to bear in mind that neither the police court or the divorce court had had any extra work in consequence of the last federal elections at which women voted. Apparently these remarks were greeted with laughter. So to celebrate the achievements of Flos Greig, Melbourne Law School was honoured in 2022 to establish the annual Flos Greig Lecture in Law, presented in partnership with Cornwalls. And Cornwall's involvement in this lecture is very relevant, given that upon graduating from Melbourne Law School in 1903, Greig undertook her articles with Frank Cornwall, later continuing her career with Cornwalls. And I know that we have a number of people from Cornwalls here this evening. 2024 is the third year we've had the pleasure of presenting the Flos Greig Lecture. In 2022, we hosted the former Melbourne Lord Mayor, Sally Capps, and last year we were honoured to host the Honourable Marilyn Warren, ACKC. Tonight, we're equally honoured to have the Honourable Linda Dessau with us this evening. As was Flos Greig, Dr. Dessau is a University of Melbourne alumna, graduating with a Bachelor of Laws with honours and being admitted as a barrister and solicitor of the Supreme Court of Victoria in 1975. She has worked as a solicitor and a barrister across commercial law and family law matters and was appointed a magistrate at the Magistrates Court of Victoria, the Children's Court and the Coroner's Court. In 1995, Linda was appointed as a judge of the Family Court of Australia, where she served for 18 years. Amongst many other roles, Dr. Dessau was the second woman ever appointed as a commissioner on the AFL Commission. She served on the board of the former Melbourne Festival as president and was a member of the Council of Trustees of the National Gallery of Victoria. She was appointed Governor of Victoria in 2015 and was the first woman to hold that role. She then served one of the longest governorships in modern times, serving until last year. In 2010, Dr. Dessau was made a member of the Order of Australia for services to family law and the community. In 2017, she was made a Companion of the Order of Australia for eminent service to the people of Victoria, and in December 2022, she was appointed as a Commander of the Royal Victorian Order by King Charles III. And I should say that that seems like a lot, but in fact it's probably a small and minute part of actually an extraordinary biography. Tonight, the former Governor will speak on the topic, "If I had my time again over, would I study law?" And so I'll leave you to contemplate that possibility. As written in this lecture's synopsis, occasionally we should all pause to reflect on what might have been if we'd taken a different path in our professional life choices. Personally, I would have missed out on many friends who are joining here this evening. The former Governor is perhaps more equipped than any to ponder this topic, given her esteemed career both in and outside the legal profession. Before I hand over to Dr. Dessau, during your registration for this event, we offered a chance for you to pre-submit questions that you might have on the topic, and then we will have a Q&A which will be hosted by my colleague, Professor Heather Douglas, who is our Associate Dean, Advancement and Engagement, and also an acclaimed researcher and expert across the area of domestic violence and criminal prosecution. It is a pleasure to have her lead this Q&A session, and then finally, Veronica Ikvides, a partner of Cornwalls, will close the proceedings. Please note that this lecture is being recorded and will be made available on the Melbourne Law School website. I will now hand over to the former Governor of Victoria, Dr. Linda Dessau, for the 2024 Flos Greig Lecture.
Thank you, Professor Duxbury. Can I say it's a pleasure to be here this evening with all our distinguished guests. I'm delighted that Professor Douglas is with us, and can I say the Honourable Marcia Neve is someone it's always very special for me to see. More about her later. I think that Her Honour Judge Caitlin English might be with us, and if that's right, she's another wonderful part of our profession. But everyone's a distinguished guest. I'm thrilled to be here. I join in acknowledging the traditional owners of the land on which we're gathering this evening, and I also pay my respects to elders past and present. Well, I'm delighted and honoured to present this lecture named for Flos Greig. At first glance, we do seem to have a little bit in common. She and I both studied, as we know, at the University of Melbourne. We both studied law. We're both female. And I think we were both 16 when we started the course. We had some overlapping experiences too, overlapping in terms of interest, not timing, when it came to the Children's Court and the Lyceum Club. More about that in a moment. In truth, however, the similarities end right there. And that's because Flos Greig was a legend. She was a groundbreaker, as has been said, a pioneer. She was extraordinarily courageous. She had to be, specifically in order to overcome the disability of being a woman. You'll know that I haven't made up that description of disability because, of course, she wasn't able to enter the legal profession until 6 years after her studies had started, and she had helped champion the Victorian Legislative Assembly's passing of the Women's Disabilities Removal Bill, also known as the Flos Greig Enabling Bill, and only then could she take up the compulsory articles of clerkship, an opportunity offered to her by a Melbourne solicitor called Frank Cornwall. So I think we can all join the dots to this lecture, supported by the very well-respected law firm of Cornwalls. You can readily appreciate that, indeed, Flos Greig was courageous. She had to be. Forget about critical mass. She was one out as a woman without another like her at the time. And for all that, she fought causes. She lobbied to establish the Children's Court of Victoria, for example, where many years ago I took up my first judicial appointment. She helped found the Lyceum Club, and she became the first president of the Women's Law Society, both of which I've had the benefit of being a member in the past. My generation of women in the law school here and later in practice, especially at the Victorian Bar, have often been called pioneers. Well, when we look at a true pioneer, it's clear that although we were in the midst and perhaps even at the vanguard of an evolution, we weren't pioneers in the manner of this extraordinary woman. When I started law, about 1 in 5 students were women. When I signed the bar roll in 1978, I was something like the 53rd woman to do so, and probably amongst about 30 women at the bar at the time. Well, Flos Greig was something else, and that's why I'm so pleased that this initiative recognises her and why I'm honoured to deliver this lecture named for her. I'm pleased, but only really partly pleased, because it's an incredibly daunting process. When you're asked to deliver a lecture, you look at the illustrious speakers who've gone before, and then you're given a blank canvas with permission to choose any topic at all. So in exercising that choice, I've reflected on the privilege of having studied law at this university, of course, being ranked the highest in Australia, and in this law school ranked in the top 10 in the world. So of course I'm proud for that opportunity. But it did also prompt me to ask that question: if I had my time over, would I study law? And the answer? Well, there are reasons why I would, and there are reasons why I wouldn't. But so that the Dean and others can relax, spoiler alert, on balance, I think I would, but I'll come to that. But let me explore that a little, starting with some background or context. When I started law, I was, as mentioned, 16 years old, and this is a great time to clarify something that seems to have crept into descriptions of my career, descriptions by others, when I've heard it said that I was the youngest law graduate from this university, and that quite simply is a claim that I can't possibly make. It's just, I'm sure, inaccurate. In any event, I was young, and so my decision to study law certainly wasn't an informed decision. Like so many others, I didn't really know what I would want to do in the longer term, a reason why the now well-entrenched Melbourne model makes such good sense. But there are additional reasons that my decision wasn't well informed beyond the simple fact of immaturity. I think first, like so many others of my generation, the option of the sciences had been closed to me early on. Not specifically and not deliberately, but I was simply encouraged to play to my strengths, and my strengths appeared to be in the humanities, and so I was easily persuaded. It's always easier to do what you find easy than to stretch yourself to something that's harder if you're given the option. So with a limited palette of options at university, I initially chose social work. However, social work did not choose me, because there was a hard age requirement of 19 to reflect the maturity required in that field. And apparently you don't need to be as mature to study law as you need to be to study social work. And although the university generally required an entrance age of 18 for any degree course, it wasn't too hard fixed, and they let me talk my way in. The only other context required to understand my observations this evening is that my ruminations now as to whether I choose law are in no way based on a dislike of its practice. In fact, I absolutely loved it, just to confuse you all. I loved it from day one to whatever numbered day it was some 4 decades later, and someone stronger in the sciences can calculate how many days that would have been. I loved my early years as a solicitor, learning on the job and being well trained by masters in old school ways as to professional standards and ethics. I relished the challenges and the fun of the bar, building a practice, learning the ropes in the courtroom, divining the respective expectations of each judge and how best to adapt to them, responding to the different styles of different opponents, and my skills of negotiation were, by necessity, really well honed at the bar. And in the trenches of adversarial litigation, lifelong friendships are forged and were forged for me. I really enthusiastically embraced the exciting opportunities across 3 years prosecuting criminal trials in Hong Kong, practising with and learning from lawyers from right across the Commonwealth. And living in Hong Kong was such a fantastic experience, and I would advocate for anyone to grab any opportunities to live and work in a different culture. Following all of that, I absolutely loved judicial life, which started young for me. I was 32, I think, or 33, when I had my first judicial appointment in the Children's Court. Again, it seemed that if you were little, you could work best with little people. You know, if you were young, you know, in retrospect, it's the court where you need the most maturity, but I was put there very young. And then I was appointed to the Coroner's Court and the Magistrates' Court, and later, as you've heard, to the Family Court. And I relished everything that I did in that court, the work, and teaching judgment writing over many years and other practical judicial skills, and working on all sorts of programs that were directed to improving our processes and our service to the community. So, a reflection this evening on whether I do it again is certainly not based on any regret or any disillusionment on my part. It's simply that with the passage of time and with experience and hindsight, I'm able to evaluate the course more fulsomely than I could assess it when I chose it in prospect. So that brings me squarely to what in particular drew me to and did keep me engaged across all those years. Well, first, there's the basic stuff. And the basic stuff that appealed to me from the start is the rule of law. I really liked that. I liked it at the beginning, I liked it while I practised, I still like it. I easily got why it mattered. I got how it could offer equal protection to every citizen and every institution. I appreciated how and where it stood between the citizen and the state, how it was capable of protecting and promoting rights and justice. I never liked injustice, which is hopefully a majority view. Although my experience of the world was limited when I was starting out, I readily understood how the certainty of rules promoted community order and business, as well as all the fundamentals of human rights. And I do love rules and structure. That hasn't changed. It didn't take me long to appreciate the clear thinking that legal training gave me to identify a problem and to analyse the means towards a solution. But actually, when I say it didn't take me long, that's not entirely accurate. It did, in fact, take me quite a long time to understand and appreciate legal thinking. At first, I really disliked studying law. I don't know if this is anyone else's experience. I struggled with what felt like contorted thinking. I didn't quite get the logic of it compared to, I'm not quite sure what, but it was just a freer or more creative way of thinking. I might not be the first to say that, and I'm certain I'm not the first to say that it was thanks to some of my great lecturers and tutors that I didn't give up the course. So one was a young man fresh from Oxford, Gareth Evans, later the Honourable Gareth Evans, ACKC, Australia's Foreign Minister from 1988 to 1996. In my second year, he taught me torts and later constitutional law. So 2 things about him. First, as to how he encouraged me in second year when I knocked on the door of his office and walked in and told him I was thinking about giving up law. He asked me why, and I told him I just didn't like reading cases. He said that he didn't like reading them either. And he hinted at a few shortcuts, which may or may not have included just reading the head notes and doing that. Secondly, I could never have guessed in the third year of my law degree as Gareth Evans set out the fundamentals of constitutional law, that one day I would be ever so grateful for that starting point in the role of Governor that saw me as the guardian of our Victorian Constitution. And then there was Marcia Neave, as she then was, now the Honourable Marcia Neave, former illustrious judge of the Supreme Court and the Victorian Court of Appeal, former Royal Commissioner, wonderful person. And I turned to her when I saw she was sitting behind me and said, I promise I'd already written something about you before I knew you were coming tonight. Marcia taught me equity, and it's a subject that is by reputation a complex one. But in the hands of such a sublime teacher and communicator, it wasn't. It was fascinating and, yes, logical. And studying equity probably gave me the first hint that I could really get to love the law. It was so much about fairness and sensible outcomes, and they were pretty good fundamentals in my mind. And that was a bit of an epiphany for me because the logic of it all finally clicked, and I began to appreciate the power of the skills that I was learning. After law school, it was clear to me in both my professional and private life that generally I was becoming quite adept at working my way through a problem. All those awful law exams seemed to have taught me a structure to analyse the issues on the way to an informed conclusion. They enabled me to take emotion from the equation in favour of logic. I'd learned clever devices. I'm assuming most of you or many of you this evening are lawyers, so if I tell you one of my personal favourites was confess and avoid, you'll know what I mean. I just loved how it disarmed people when you started with an admission against interest before embarking upon an absolutely killer point. So I began to see how powerful it was. I felt the privilege too of learning to be comfortable with robust discussion. That is, that you can confidently argue an issue rather than playing the man, as it were. I was an AFL commissioner, so you'll forgive the footy reference. You can disagree, but without bad blood. You can listen to and even appreciate another side of a debate. And most importantly, I learnt that if you listen carefully to another side of the debate and you formulate distinctions that are persuasive of the point you want to argue, it's particularly good. And across my years in legal practice, in the judiciary, on boards and as Governor, I've appreciated more and more that all these qualities or skills are not just nice to have. There's so much more than that. In legal practice, for the best drafting of letters, opinions or documents for litigation or for effective advocacy or judging, the capacity to firmly and concisely put a position based on facts and logic is just fundamental to everything you do. At a board table or in any group setting, the capacity to engage in that robust discussion, comfortable with a freely expressed diversity of views, always leads to better decision making. And how much better would we as a community be if public discourse were guided by all those principles rather than what we so often see? Facile, shallow and lazy opinions formulated in the echo chambers that are hostage to the algorithms that can choose what we see and what we read. And really aggressively expressed views which overlook any opposing viewpoints with an emphasis on attack rather than open listening that might just promote a reasoned discussion. So, with all that apparent enthusiasm for the law, why have I even questioned if given my time over I'd choose law again? Well, the first reason is actually a big one. It's that somewhat belatedly I was exposed to science and business and many fields of endeavour that were otherwise unfamiliar to me. And when I say somewhat belatedly, I mean really somewhat belatedly, probably within the last 10 years. So let me explain. It was really mainly as the Governor of Victoria that the world opened so much more widely to me. Even though I'd been involved in so many different parts of our community life before then, I hadn't had some of the opportunities that I had as Governor. I know that for those of you who did constitutional law, particularly with Gareth Evans, you'll all know what a Governor does, but just in case some of you have just forgotten third year con law, there are four main parts to the role, and the first, of course, is the constitutional role, the Governor being a guardian of our constitutional democracy and our processes. The second part is ceremonial, so it's the Governor that you'll see on the steps of the shrine on Anzac Day, speaking on behalf of the whole community. That's actually one of the joys of the role. You will recall from con law or perhaps politics that as a matter of convention, the Governor doesn't vote. And the Governor doesn't vote because he or she is entirely apolitical. So when you do stand on the steps of the shrine, you do speak for everyone. The third part of the role is international engagement, very, very important in the modern time because we can't be at the bottom of the world and not engaged with the rest of the world. And finally, there's the community part of the role through which the Governor works to bring the community together, to highlight and thank all the wonderful people who are doing extraordinary things, and to encourage not only achievement but harmony throughout the community. Well, very early in my time in the role, I realised how often my work was relating to the sciences. We toured Victoria's world-leading research institutions, many of them actually connected with this university, but well beyond as well. We met many of our brilliant scientists. We hosted many international guests who wanted to partner with them, and we met a lot of the young, clever people studying STEM, and we were trying to encourage more to do so. I think for me, what happened was for the first time in my life, I came to appreciate why science actually mattered. I lost my fear of it. I realised it wasn't as mysterious and scary as I'd believed at school. It was factual as well as, in fact, quite magical, and it was everywhere and in everything. I'd always seen it as something separate and something over there, but everything we touch, see and do, of course, has science in it. And I thought that the law was based on logic. Well, who knew it? So science, with bells on. I realised that perhaps a bad experience with a Bunsen burner or dissecting a rat or something like that in what was it called? I mean, now year 9, third form in those days, had put me off and had been allowed to put me off. But that's not the end to my discoveries. I also discovered more about our businesses and the clever people who start, run and or grow them. I learnt about their entrepreneurial spirit, and I learnt about the ideas and vision that they courageously pursue into a new or an existing business, and the incredible risks and responsibilities that they take on when they're responsible for so many other families who work directly or indirectly with them. They're brave and they risk so very much, and I realised that these were people that I'd not always thought about a lot in the course of my career. Across a number of years too, sharing board tables with people from different sectors also was a revelation for me, and a happy one at that. I'd always had a belief in diversity, but my belief was fully endorsed sitting around a table and seeing the successful ferment when different people from different professional backgrounds sit down to discuss what are often sensitive and complex issues. I became well aware as to why we certainly don't want all lawyers around a board table. I can spot a risk a mile off, and so could the other lawyers. And we were terrific at talking endlessly about them. But those important skills are all the better when they're surrounded by the skills of commercial thinkers who, respectful and grateful for the risks identified by the lawyers, so often devise creative solutions that manage to fairly balance the risks against the sort of inaction that we might otherwise fall prey to. As well, for all that I've known and seen that law can achieve, I've also known and seen disappointments. Primarily, I've seen how too often it's slow to keep up with social, scientific and technological advancements. I think back to when, for example, clever scientists first achieved successful pregnancies through IVF. It probably all seems quite unremarkable nowadays because it's been a long time. But initially, the procedure was considered, well, if not a bit sci-fi, at least something that raised a variety of ethical issues, including a fear of genetic engineering. Where were the lawyers throughout the considerable period that the researchers were working on the science behind IVF? And although with the fast advancement of technology, the law has become more adept, I think, at keeping up. And it is pleasing to see more and more startups, for example, with lawyers embedded within them, so they work alongside the tech people from the beginning. There are still many contemporary examples of where the law is playing catch-up. And I think of AI and the complex ethical issues that arise from it. It's an obvious example where the science and the tech has just advanced so quickly and we need law to keep up. So what else would make me reconsider a life in the law? There's another big one. It's that I don't believe that our courts always deliver. Now, before anyone goes to the media or any media start tweeting, I better explain. Between my husband and I, and he wishes he could be here tonight, he's had back surgery, it's a very weak excuse, but he's fine. Between us, we have 38 years in the judiciary, nearly 4 decades. So we know how hard judges work, we know how hard it is to be a judge, we know of the long hours, we know of the exacting work, the relentless caseload, the public glare, and the toll of the sad and the bad and the heartbreaking people that flow through our courts. But at the same time, we do know the importance of the role, the privilege of serving to uphold the principles and the rights that attracted us both to law from the start. And we do know the enjoyment of an intellectually stimulating and professional life. That's why I chose to spend a total of 28 years in the judiciary. So any criticism that I make of our court system is not born of any personal career disappointment. It's fuelled, in fact, by the frustration I feel when I see serious delays in our courts. And I've felt that for my entire career because it's nothing that belongs to today or yesterday. It's a persistent and pertaining issue. Or a sustaining issue. Delays that by their very existence undermine everything that we loved about justice when we started out. Delays that undermine or weaken the rule of law. Delays that mean that accused people can be in custody for long, often unconscionably long periods awaiting a trial, and therefore before an offence has even been proven. Delays that see developers stymied in their efforts to build, including to build much needed housing, by protracted planning proceedings, and delays that in my own last jurisdiction of family law saw the damage and the fracture in relationships when a child didn't see a parent possibly for years, pending a hearing as to whether the child should or should not see the parent. Or how lives were held in limbo, economic damage incurred, and mental health really severely affected when property settlements were unresolved, sometimes for years. So we need to reckon the cost to individuals, the loss to the economy, and the impost on the wider community resources when delay in the courts cause such widespread damage or failure. And these are systemic problems. These are not problems that you shoot home to any one particular court, to any one particular judge, to any one head of jurisdiction. They're far broader than that. Without any question, courts and court personnel, including judges, carry a responsibility to work hard and strive to improve the systems that will deliver prompt judgment. And for the most part, I saw that responsibility met very, very well. Experienced judges and court leaders consistently sought ways to smooth the path to proceed in as timely a way as possible. But courts do need the right resources, and for the fullest success, I think there needs to be a compact between government for the appropriate resources to be met with appropriate rates of work and the best case management to be delivered by courts. But that perfect balance is too often elusive. So all that said, if I had my time over with those disappointments or those changes in the way I've seen the world, I think I would still study law. The basic principles and skills still appeal to me. That hasn't changed. And experience tells me that the skills are never wasted. Mind you, starting over, I might do things a little differently. I'd study law, but I would enthusiastically consider being amongst today's large number of law graduates who don't specifically practice law. I realised that the linear legal careers that I had and my husband had were much more an expectation of the past than they are of today. When we told some of the senior people at the bar that we were heading to Hong Kong when we'd both been at the bar for a few years, one of them said to us, "Are you sure you want to do that for 3 years? You know you'll take silk later." And that's an interesting attitude that I think has probably changed enormously. But our careers in those days were so linear that it meant that you were going to do everything not only in an obvious chronological way, but even with perfect timing. So I think today, seeing how legal skills can be so well used in broad pursuits, knowing that they'll always earn me a place at the table, and appreciating that they are life skills as well as career skills, I might look beyond just practising law. We have 2 sons, both of whom did law, neither's practising law, and that would be not at all unusual, and thank goodness, because we're turning out more lawyers than we could have as lawyers. So my conclusion would be it's an extremely fortunate degree. It gives a practical path to a profession that can hold such great satisfaction and has for me, and it can open a multitude of other pathways too. So it's a valuable degree and I'm really grateful for it. So thank you.
Good evening, distinguished guests, ladies and gentlemen. My name is Veronica Ikavides and I'm a proud female partner at Cornwalls. It is a profound honour to be with you for this remarkable event. Cornwalls proudly sponsor the Flos Greig Public Lecture for the 3rd consecutive year. On behalf of Cornwalls, I extend our heartfelt gratitude to our esteemed guest lecturer, the Honourable Linda Dessau. Thank you for sharing your valuable reflections on your distinguished career in law and pondering whether you would choose the same path again. Your insights into the profession and the choices shaping our careers have been thought-provoking and inspiring. As someone deeply committed to advancing opportunities for women in law, I found your discussion particularly resonant. Your reflections offer much to consider, and I too have been moved by the points that you have raised about the evolving nature of our professional journeys. Professor Alison Duxbury and the Melbourne Law School, thank you for your continued support and dedication to this event. It is deeply valued. Your vision and commitment to honouring Cornwalls alumni, particularly the trailblazing Flos Greig, have been instrumental in making this public lecture a success. We are also delighted to have Eola Matthews, the great niece of Flos Greig, with us tonight. Eola, your continued support and the insights that you have shared about your great aunt add a special dimension to our celebration. A sincere thank you to the University of Melbourne, the Melbourne Law School, organising committees, and to all the volunteers who have worked tirelessly to bring this event to life. Your behind-the-scenes efforts ensure that each lecture is delivered with excellence. To the catering staff, support crew and technical team, your hard work and dedication are greatly appreciated. This event would not have been possible without your support. Finally, thank you to each of you for being here tonight. Your presence reflects a shared commitment to honouring Flos Greig's legacy and ensuring that the future of women in law in Australia is filled with opportunity, equity and meaningful engagement. Cornwalls is delighted to continue its partnership in this lecture series, recognising Flos Greig's pioneering spirit, which transformed the basis of admission to the Australian legal profession. Our ambition is to establish this lecture in the long term through philanthropic support, and gifts of any size are warmly appreciated. Enjoy the evening. On behalf of Cornwalls, we look forward to continuing to support the Melbourne Law School Public Lecture Series. We hope to see you all again next year. Thank you.